Morning, Judge.
Morning, Matthew. Okay, good morning, everyone. First up is Jimenez Tidman Conan. And let's see. I don't see Ms. Johnson. She's the worker on this one, right, Matt?
That's who I had down. I didn't see a court report, Your Honor.
I did not either.
All right, well, we'll let Molly in and maybe she can.
Yeah, maybe I had the wrong worker. It's possible.
I did receive a court report.
Is it from Jackie Johnson?
Yes.
Yeah, I did too. I think it was yesterday.
So, Ms. Wagner, do you know who's supposed to be covering the Conan Garcia Stidham minors?
I do not know.
Okay, we were hoping. We've got Jackie Johnson down as a worker, but she hasn't logged in yet.
Yeah, and I don't even know who the supervisor is on, but I can shoot a text to Sarah and see if she knows.
I just emailed Ms. Johnson and Ms. March, who I believe is her supervisor.
Okay.
And I'm not seeing any of the parents. I let one parent in from another file, not just because of the way the waiting room jumps around as I'm letting people in.
Honor, my client, Mr. Conan, according to the report, is in inpatient residential. So, assuming he's still there.
Well, if you folks got reports, I guess we're prepared to move forward. We'll see if Ms. Johnson shows up before we finish the hearing. Counsel, could you please identify yourselves for the record?
Matt White, Prosecutor's Office.
Ken Hotchkiss appearing on behalf of Ashley Conan.
Mike Kelly on behalf of David Conan.
Rebecca McCluskey, guardian ad litem.
So Ms. McCluskey, how are all these children doing?
So I did check. Obviously, Anna and Selena are placed in the same placement with a grandmother. I know Anna's case just closed due to the guardianship being finalized, but she's doing okay. The kidney, just a quick update on her. The kidney's not being rejected. There are some other secondary medical issues that have arisen, and she's been in the hospital quite a bit, but otherwise doing okay. Selena is adjusting well there. She's sounds like she's in counseling. She's just recently switched to a new counselor. Placement has kind of high hopes that she'll connect with this new counselor a little more readily than she did with the previous one, but she's doing okay. Everyone's doing good under the circumstances, considering what they're going through and the pandemic and distance learning and all of that. I did not get, Jacob was recently moved. I did not get placement information for the new placement unless it's not titled in any manner I could find it in my inbox, but I did get that contact info from placement for Anna and Selena. So I was not able to make contact with Jacob's new placement, but I will do so now that I've been provided that contact info. I did not receive a court report. Again, I searched the case, I searched the minor's name, I searched the worker's name. I did not find that, so I don't have a court report at this time. Thank
So,
you.
Mr. Hotchkiss, you did get a report?
I did, Your Honor.
Unless it was late, if it was late afternoon yesterday, I have not checked email at 1 o'clock yesterday.
All right, so I am going to go through the recommendations on the record. Both parents participate in substance abuse treatment and screenings until their providers report services have been completed and are no longer needed. Both parents participate in a psychological evaluation and follow through with the resulting recommendations. Both parents secure and maintain safe, family-friendly housing and transportation. Both parents participate in and benefit from parenting education. Ms. McCluskey, do you believe those recommendations are appropriate under the circumstances?
I do, Your Honor. No objection. Thank you.
And Mr. Hotchkiss, any objection to the recommendations?
Your Honor, I do not have any objection. However, I've not had a chance to review them with my client. She's was unavailable or unreachable by telephone, and it looks like she's not been in contact with the agency the last half of this order. So even though I don't really have any objection to them, I guess I'd leave it in the court's discretion. Thank you.
In light of what you just indicated, I think I'm going to add to the order that both parents maintain contact with the foster care worker.
Thank you, Your Honor.
And let's see, Mr. Kelly,
Yes, Your Honor.
any objection to the recommendations?
No, Your Honor, it seems to be a fairly positive report for Mr. Conan. Hopefully that keeps up and he completes his residential treatment. Thank you.
Okay, I will make these recommendations as modified on the record. And we'll set our next review hearing for,
Oh my gosh, I don't even have any of my stuff. Hang on one second.
hold on a minute. So Happy New Year, everyone.
Happy New Year, Judge.
New Year.
Here.
March to April. What's today? Okay, let's do March 30th. And let's do it at 8:45.
March 30, 8:45. Thank you. All right, next up is Barn Hill. We're just a few minutes early, but by the time I get everybody in here, we should be ready to roll. Let me see. And Ms. Wagner, you are on this matter, correct?
Yes.
Parents' names?
Nora Porter is the mother.
She's not present?
Probably not. She was made a non-respondent, or
Okay.
the reunification efforts were stopped for her.
And Mikhail Barnhill is the father. The goal is guardianship, Your Honor. I don't have a valid number for my client. So
The foster parents should be on. Or the
Do you know
relative.
who you know who they are?
Brooke and Richard Wandell.
Okay, I see that. Brooke Wandell is signed in. Are they the proposed guardians?
Yes.
Okay, so I could have counsel state their appearances, please.
Matt Way, Matt Way, Prosecutor's Office.
Molly Wagner, DHHS.
Ken Hotchkiss for Nora Porter, mother.
Mike Kelly on behalf of the father.
Rebecca McCluskey, guardian ad litem.
Okay, so are we making progress towards finalization of guardianship?
We're still waiting on a few things for the licensing to happen. There's been some things with the house that have kind of set back the licensing process. But licensing is trying to find ways around that so that we can move forward. So we're hoping, I'm pretty sure that the licensing worker has pretty much everything she needs paperwork wise, or she's really close to that. But we need approval to move forward. There's like a, Richard, is it the storm drain?
Yeah, it's the drain field from the septic tank. It's old style instead of raised.
So when the inspection was done through the health department, they failed because of that. So we're trying to find a way around that. And we're hoping to know something within the next month. And then once the licensing is completed and they're licensed, then I can file for the guardianship.
So Mr. Wandell, are they telling you you have to put in a raised bed drain field?
To be fully up to code, yes, it'd be kind of like a raised drain field. I currently rent, so I'm not going to drop 15 grand into that at the moment.
I'd be surprised if you could get it done that cheaply.
Well, being with the farm, my boss knows a lot of the excavation companies and stuff. But
So, Ms. Wagner, we're at least 6 months out from being able to finalize because they have to be licensed for 6 months before we can seek guardianship subsidy.
Well, I think because there's something with, if they're relatives, the kids, I can't remember exactly what it is, but we can file as soon as the licensing happens.
Oh, well, that's good.
Yeah.
Ms. McCluskey, how are the children doing?
So I was able to leave a message. I didn't give placement a long time to call me back or make contact coming back from the holiday. So that was not any fault of their own. We had a string of reviews where their voicemail box was full. So at least I could leave a message, but I couldn't speak with them. I did get a court report for this file and I did review that, and it looks like the children are doing very well. I know they have done very well in this placement. I have no concerns at all. I have no objection to the goal of guardianship. Thank you.
And Ms. Wagner, any other updates to your report?
No, I don't have any more updates.
And Mr. Kelly, Mr. Hotchkiss, any objection to the recommendations?
No, Your Honor.
All right, they seem appropriate. I will order them. We'll set our next review hearing for
March 30th at 8:45.
March 30, 8:45. Thank you.
Thank you.
thank you.
Next up is the Waybright Miners. Let's see, Ms. Kirk is here. And let's see if we've got any parents out in the waiting room. Would not appear so.
Your Honor, my client indicated when I talked to her the other day, she would be present. It would be a 626 number if it's.
All right, I see that. I'll let her in. Is this Chelsea Waybright?
Yes.
Okay, so Ms. Waybright is present. Counsel, identify yourselves for the record.
Highway Prosecutor's Office.
Mike Kelly on behalf of the mother.
Ken Hotchkiss on behalf of Sean Kingston, father.
Rebecca McCluskey, guardian ad litem.
And Ms. McCluskey, how are Bentley and Tyler doing?
And somehow I did not have this on my schedule this morning, and I'm just reviewing the court report. I don't know what happened there, so I just pulled that up. I know Bentley is with a grandmother who's always been placed with. I don't have any concerns with that. And last time I spoke with Tyler's placement, it was shortly after he was moved, and there had been some struggles. I was kind of hoping that placement would participate this morning, but the placement was well equipped at that time, and it appears still to meet all of Tyler's needs. And they set up services appropriate to his needs right away. I have no objection to the recommendations, and I have reviewed the court report. Thank you.
Ms. Kirk, what's the placement's name?
For Bentley Waybright, it's Mr. and Mrs. Bellman, and for Tyler, it's Mr. and Mrs. Ayers, Ayers.
All right, I just wanted to see if any of those were in the waiting room, and they are not. Okay, so Ms. Kirk, do you have any updates for the court?
The only update I have is the Ayers did put in a request for Tyler to be moved due to not feeling like they could provide for him appropriately. We are seeking placement for him at a different home. We're actively seeking that with DHHS. The agency is also waiting for support direction regarding substance abuse screenings, as I know that we had emailed regarding differences between adult health screenings and probation screenings regarding Mrs. Waybright. So we were asking the court to do a court order for hair follicle testing so that we could move forward with supervised visitation if that is negative.
And tell me again the source of that testing.
We would be going through DHHS for the hair follicle, whoever that they would be able to pay for and that we could find in the area to do the testing.
So I know we've used hair follicle testing as a fallback in the past, but I've become aware of some questions raised as to how reliable hair follicle testing really is. Mr. Way, you want to weigh in on this? No pun intended.
Despite the way you emphasize the word way, Your Honor. So my understanding is every time we try to do hair follicle testing, it becomes more and more difficult because most places just don't do it. I think there's a level, based on the research I've done, I think there's kind of a level of randomness to it. It really only catches heavy, consistent usage. So I'm always hesitant to, I don't know what exactly it really tells us. And I know we've talked about having somebody come in to testify about that, but
What's the specific discrepancy involved here that's raising this issue?
With the AverHealth testing, the cutoff levels for basically methamphetamines is much lower than the probation testing. That's a urine drug test. So it's 12.5 nanograms for AverHealth, which is a mouth swab, versus the urine drug test, which is done for Adam, which is only which is as high as 300 nanograms that it can be positive for. So she is tested positive through AverHealth screenings for methamphetamines. But she's tested negative for Adam for the urine drug screen. So we're kind of at a standstill as to what we should do regarding moving forward. I know DHHS had just emailed me early this morning stating that if the court is not willing to accept AverHealth drug screens, that they would find another place for her to screen at.
Your Honor, the problem is the cutoff levels are dramatically different. What she's testing for her urine screens are in milligrams, which is 1/1000th of a gram. The average testing goes down as low, according to the court report, 3 nanograms, which is 1/100000th of a gram. So that's a significant difference in terms of a cutoff level. And I'm sure Matt's probably researched it as well. It seems like most cutoff levels are right in the 250 to 500 range, as opposed to being all the way down to 3. So maybe it's their testing procedures. I don't know. I talked to my client yesterday. She's willing to do a hair follicle test. She indicates to me she's been clean for several months. She doesn't have any concerns with it coming back positive. She's befuddled as to why the other ones are coming back positive, but the urine screens aren't. So we'd be willing to do a hair follicle test if the court wants to order it. She has no concerns that it would come back anything other than negative.
Well, given what I just heard, the likelihood that a hair follicle test, if we can even get one done, is going to invalidate the Adam testing is probably pretty low. So the communication I received from SCAO about AverHealth wasn't a criticism of their testing levels. It was a criticism of the underlying reliability of the test at all. With that cloud hanging over AverHealth test results, and the fact that the Adam test results are negative, and with the exception of cases that DHHS is involved in, Adam is relied upon throughout the court system as a reliable resource. I'm disinclined to order a hair follicle test. I'm more inclined to say, as long as she continues to test negative through Adam, that's good enough for me. Anyone else want to weigh in on that?
No, Your Honor, we would agree with the court's assessment.
I don't really have much of an argument one way or another. I know they were in the process of reviewing AverHealth, and I have not heard any update on that, but I will certainly ask, because this is going to continue to be an issue, certainly.
If the issue is AverHealth, is that they have an unrealistically low threshold for a positive test, it seems to me they could change their threshold if that's the only condition, if that's the only problem. But if the problem goes beyond that, I don't, I guess the future of whether the agency should even be using AverHealth is in doubt. But until I get some further guidance from Scale, I'm going to go with what's in front of me. And what's in front of me is we got questions about AverHealth's reliability. We don't have any questions about Adam's reliability. So what I'm going to order is that as long as she continues to test negative through Adam as a condition of her probation, that's sufficient for the court's purposes to be satisfied that she has that she's not using.
With that being the court's ruling, Your Honor, we would request that she be allowed to have some unsupervised parenting time. It sounds like she's doing fairly well in her treatment plan. After when I spoke with her yesterday, it's just limiting her time that she gets with Bentley and Tyler at this point, with it still being supervised. Thank you.
So, Ms. Kirk, were there any other concerns other than the AverHealth that would be a hindrance to unsupervised parenting time in your assessment?
Not at this point, Your Honor. We were just waiting for the court to make a decision regarding if we should allow the Adam testing versus AverHealth. We're willing to allow unsupervised visits. She's doing very well during visitation times. I mean, obviously both boys have behaviors, but she's working on dealing with those, and we'll continue to keep an eye on that, even with as we go to unsupervised visits. So no, there's no other concerns.
The issues with Tyler and placements, desire to have him moved, is that because of Tyler's behaviors?
Yes, well, there's both. He was placed in a home with another 3-year-old around the same age. Just seems to be some issues regarding he could do better if he was the youngest child or if there wasn't another child the same age. So yeah, there's been some behaviors. He was also close to his last placement. So yeah, it's just based on behaviors, but I mean, nothing extreme.
Okay, Mr. Kelly or Mr. Hotchkiss, any objections to the recommendations today?
No, Your Honor.
Your Honor, I've not had contact with my client quite some time, so I'd leave it in the court's discretion. Thank you.
All right, so I will implement the recommendations as modified on the record. We'll have our next review hearing.
Okay, we'll go on the same day. Let's go for that March 30th at 8:45.
March 30, 8:45. Thank you all.
Thank you.
Okay, next up is Collier Lovett, and I know we've got a few people here on that one. Mr. Lovett is signed in twice.
Well, there are two Mr. Lovett.
Are they both Kevin?
One's Lyle, I think.
Yeah, I've got Kevin Lovett signed in twice.
Okay.
Let's see. Ms. Hunt is here. I see someone from the tribe, Heidi Nesberg. Let me get her in. And I see a 906 phone number, which I'm going to assume is on this file.
Yeah.
Yes, I just let in a 906 phone number. What is your name, please?
Veronica Russo.
All right, you're in the right place then.
Okay.
And let's see if we can't get Mr. Lovett here. Shannon, I don't see the mother or the father listed on the.
Probably because we don't have an address. We haven't had addresses for them for a while.
Oh, okay. Let's see. I've got a few other people in the waiting room. Let me make sure I can identify who they are.
Yeah, Judge, we haven't had addresses for them for.
All right, I've got an unidentified device. I'm going to find out who that is. All right, Ms. Russo, I'm going to mute your phone for now because we're getting some background noise. All right, I've got someone on a Galaxy device. Did anybody recognize that gentleman when we could see his face? Apparently not. There we go. Does anybody recognize him? Sir, on the Galaxy device, if you can hear me, what's your name? All right, let's try again. I've got someone on a Galaxy device in my courtroom. What is your name, sir? It looks like we're having trouble making that connection. Sir, can you hear me? Ms. Hunt, do you recognize the gentleman in the blue sweatshirt?
No, I do not. I'm sorry.
All right. Can you at least verify that he's not on this file?
That is Kevin Lovett. Is
Oh,
Kevin
it
on?
is. Okay. All right. Very good. Then he's in the right place, but it looks like he's having trouble making a connection. So, ma'am, your screen indicates that you're Kevin Lovett. Obviously, that's not true.
Phone set up under my husband.
All right. Okay, well, let's go with what we've got here. Let's have everybody, starting with Mr. Way, identify themselves for the record.
Matt Way, Prosecutor's Office.
Ken Hotchkiss on behalf of Veronica Rousseau.
Rebecca McCluskey for Keegan Lovett.
Ivan Brown, LGAL.
Katie Nesber, caseworker for Sioux Tribe of Chippewa.
Ms. Russo is present. Looks like Kevin Lovett is present, although for some reason he's having trouble making a connection. And I'm sorry, ma'am, what is your name?
Cheryl Lovett.
First name again, Carol?
Cheryl.
Cheryl?
C-H.
All right,
Yes.
all right, thank you. Okay, Mr. Brown, I believe you're LGAL on this file. How is Axel doing?
Axel's doing very well. He has been with his grandparents since the inception of this case. This is, I asked for an early review. This case was originally set for an early review December 15th. We had a snafu. It didn't get placed on the docket. And then the court agreed that we would just leave it on for the hearing that's set for February 2nd. I asked that it be moved up because certain things have occurred. Axel has actually been essentially with his grandparents since birth. I have absolutely no concern with their care for Axel, and I think that it is a wonderful placement. I want to address some things in the court report that I tried to call the supervisor, Madison Banks, yesterday at Severitas. I left a message on the answer machine to try to get the agency's side of the story on what is going on with this matter. Some things in the report.
Ivan, let me stop you for just a minute. I didn't realize Miss Banks was on this file. I just let her in. So if you could proceed now.
Yes, I left a message on the answer machine for Ms. Banks to call me so we could discuss some of the discrepancies in this report. First of all, the grandparents in the best interest placement on page 2, it indicates that one grandparent is on for adoption or permanency and the other is not. That's absolutely not true. I've been in constant communication with these grandparents. Miss Lovett merely said to the caseworker in passing that this is not something that she envisioned doing at her age, but in no shape or form did she mean it to mean that they were not going to adopt Axel. So I would like that changed. She is on board. Her husband indicates she's on board. This was just something merely in passing. Further, there was some snafu about the grandfather did a FaceTime with one of the parents. I see nothing wrong with that. That has caused the agency to come unglued that he did a FaceTime with the parent. I see nothing wrong with that. That's his son. Mr. Grandfather, that's grandfather's son. I have no idea why there would be a problem with the grandparents doing a FaceTime between Axel and his dad. Further, the grandparents do not intend to move to the Upper Peninsula until this case is over with. At some point, he said they want to. They have a place there, and wanted in the future to move to the UP, but nothing imminent. So there's no need to find a caseworker in the UP. The next issue is the grandparents wanted to go up from December 27th to January 3rd to the UP. I guess they were prohibited. And then I found out yesterday that the agency is having some meeting about potentially moving Axel. I don't have the agency's take on this and why, because I tried to call and get their side of the story of this yesterday. But I would ask that Axel not moved. I think these are good people, and I think that they should be the ones to adopt Axel. With that in mind, this case has went on for quite some time. The court indicated at the last hearing that if things did not change, that's why it set a short review hearing, that the goal would be changed. I'm asking that the goal be changed to adoption. Parents haven't been around in months and months and months and months. One of them's here today. We haven't even had addresses for them for some period of time. Thank you.
All right, so let me hear, Ms. Hunt, your perspective on the issues that Mr. Brown has raised.
Good morning, Judge. The first
Good morning.
regarding his placement with them in the event of adoption, Ms. Lovett spoke with myself and my supervisor, Madison, and she voiced the same reservations with both of us about doing this long term. And secondly, there is a safety plan in place regarding the phone call, the face-to-face. Keegan is to visit at the agency as opposed to, and is supervised by the agency. And they've been told that, and it is in the safety plan. They have agreed to the plan, yet they keep violating the safety plans that are in place by allowing Keegan to visit. At one point, he was stopping by the house, and in this case, they're doing FaceTimes, which are not allowed to be done by them. They're supposed to be supervised by the agency due to the nature of the allegation.
Well, what are the concerns there?
Then, what are the concerns?
What are the underlying concerns that result? I mean, the fact that there's a safety plan doesn't help me understand why you're concerned about placement, supervising, FaceTime, or other visits. That's what I'm trying to get at. What's the underlying concern?
There has been some domestic violence in the home, in the presence of the child, the drug allegations, and it is the parenting time was moved back to the agency at that point.
Domestic violence in which home?
In the home of Kevin and Cheryl.
I can provide some more elaboration on that, Your Honor, as well, if you'd like.
Hold on, Ms. Banks. I'll give you a chance.
Not a problem.
And drug allegations in the home, again, that in the home of placement?
Correct. There was a CPS report filed.
So I understand those two concerns. How do those two concerns impact supervising a FaceTime visit between Axel and Axel and his father?
All parenting time for Keegan is to be at the agency. That's in the order.
So it's because I included in a court order that all parenting time is to be at the agency and they're disregarding my order. Is that your concern?
I think Madison can speak more as to why it was transferred to the agency.
All right, go ahead, Ms. Banks.
Thank you, Your Honor. So just for clarification, these allegations are going back to September of 2020. We received 3 allegations over like a 3-4 month period to the end of the year. And these allegations were roughly a month apart. They were centralized intake calls done. I'm not entirely sure. I believe one was done by law enforcement because they were called at an incident. And of course, they're anonymous. So I'm not sure who entirely called them all in, but they were different. The first one included concerns of a domestic violence incident between Mr. Rousseau and Mr. Lovett during a parenting time being supervised by placement. At that point in September, we did a safety check on the child and we developed our first safety plan to move all parenting times back to the agency because of the domestic violence incident that occurred in the placement's home around the child. Even though the child wasn't directly involved in the incident, it's still inappropriate for it to occur. And that was also after discussion with both Cheryl and Kevin of placement, with concerns of these issues between Keegan and Veronica at their home, the fights and things like that. And they agreed that it was probably best that the agency supervised parenting time from then on. So that was included in our initial safety plan developed by both us and CPS when we discussed the allegations. Roughly a month later, we received another allegation stating that I believe it was Keegan was still being allowed to be in the home to see the child. The safety plan was being ignored, and that he was using substances in the home while he was at his parents' home. CPS had denied investigation, but opened it to us to investigate. So we again did a well check on the child. We found no concerns, and we revamped the safety plan and reiterated to placement that no parenting times were to occur in their home, and that all parenting times were to occur either at the agency or supervised by the agency in some manner, wherever they were. And the third call in included, this one was the one that didn't make much sense to us, but it was something occurred in the UP with Ms. Rousseau and Mr. Lovett, and Ms. Rousseau was in the hospital, and the CPS allegation included that there was a child involved with it, but with them being in the UP when whatever incident occurred, and the child being down here near Jackson, obviously that was denied as well because he was not involved in whatever incident occurred then. But again, we had to just reiterate the safety plan. So there were 3 safety plans. They said very much the same thing, and all 3 reiterized that we are not to do any parenting times at the placement's home just due to these continued concerns. And we had discussions and an FTM regarding this as well with all parties. And we explained that this wasn't a punishment to placement. This was also to protect them, that they would no longer have to be involved in parenting time. CPS calls shouldn't continue to be made, that they're violating safety plans and things like that. So all parties agreed at this FTM that we would no longer have anything to do with parenting times at placement's home, whether it was video because of distance, the parents and the child when they were in the UP, or in person. And this was agreed upon by all parties. So when we stated in the court report that this continues to be violated, it is a safety concern that for the agency, and I'm not stating that we're attempting to move the child. We haven't put anything in motion to move the child. It is a safety concern long-term that they continue to violate the safety plan and disregard it. And we keep catching them in these acts, and we've had multiple discussions. So we did bring up at a home visit yesterday that we would like to do another FTM to reiterate safety plans, to rediscuss the plan moving forward, especially on what occurred at court. It was in no way an FTM that stated we were initially moving the child. Now, if it continues to be a safety concern, it is absolutely the agency's first responsibility to keep the child safe. And if they continue to violate safety plans and disregard the reasons on why there are concerns of the parents being around the child unsupervised by us, then we might have to continue to have discussions on longevity of the child in their home, but we're not moving the child immediately. It's just that it is a safety concern and we wanted to bring it to the court's attention. So that's in regard to the safety plan. Speaking to Mr. Brown's discussion on us, our statement from Miss Lovett, Miss Cheryl Lovett, we did it, and this was a couple months ago, so if she's changed her mind, that is completely fine. But when we've had discussions with her individually, she does have reservations of adopting in long-term and things like that. It needed to be a longer conversation. And I do see her shaking her head. So if that has changed, we're happy to change that in the report. But that conversation did occur separate from her husband, and we report what occurs with us. So it's completely fine if she is more on board with it now, but that is why it's in the report. So if that's changed, we're happy to change that. In regards to them moving to the UP, if they are no longer planning or waiting until adoption's finalized, that's perfect. And that's all we request. There was discussion of moving sooner rather than later to the UP and wanting to move and some unclarity in those discussions when we ask for intentions, timelines, and things like that for them to move. And Mr. Kevin Lovett hasn't been very clear with us and has made very vague statements as though, well, I'm just going to go when I want to go and things like that, which is a concern. And we need clarification on they can't just move across the state with the child when we have an open foster care case and we don't know where he is. So as long as they don't move or we have more of a plan when they do move, or it's more of a discussion rather than us being told that they're just going to move when they want. Again, that's completely fine. It just can't be a spontaneous move and we don't know. And that goes for them visiting as well. With these CPS allegations and safety concerns that have been occurring, if they're going up to the UP near the parents, we do have some concerns that potentially the parents would see the child while there. So we just need to know specifically when they're going, the address of where they're staying. All of those things are requested for any foster child. It's not just in this case when they go on a vacation. And that's so that if there's a CPS call, if there's a safety concern, if anything occurs, the agency is fully aware of where the child is so we can address anything that needs to occur. So they're absolutely allowed to go on vacation. It's not that we're telling them they can't go. We just need to know about it. And we can't know after they've already gone, which has occurred multiple times, or the day they're going, we find out they're going. We just need more notice so that we can be prepared as well if there's a CPS call or if anything occurs and we need to know where the child is. And I believe I hit all of Mr. Brown's points, but if I didn't, I'm happy to elaborate more.
Well, the most significant one was his request that the court order a goal change to adoption.
So in our report, over the short reporting period, and I know we had submitted a report for the 15th hearing that didn't occur due to that scheduling issue. We did receive notice that Ms. Rousseau has been doing and utilizing services since October when she moved to the UP. We are finding that when Mr. Keegan Lovett does go up to the UP, which is where he is now, we are finding more issues with compliance with services. And I believe that has to do with the domestic violence in their relationship. Of her completing her services, we get silence when he shows up in her life, but then as soon as they separate, she's been very compliant. So in our court report, we weren't asking for the goal change initially because of her willingness to do services and the progress she was making on her own, but we do have concerns if they are back together, or at least living together again, because that's when we continuously lose contact. But based on a communication we had yesterday between the tribe and us, it sounds like she's trying to separate herself from Mr. Lovett again and end that relationship to be more healthy and positive. but I haven't had an opportunity to speak with Ms. Russo regarding all of this since it happened yesterday.
And I can assume that part of Mr. Brown's concerns are Axel's been in care since September of 2019. Mom's been slow to engage and periods of non-engagement. How much more time are we going to give her? How much longer is Axel going to remain in limbo, waiting to see whether or not Mom can get her act together?
And we as an agency, Your Honor, we share that same concern. And I know there was 2 court hearings ago, we were looking towards a goal change ourselves prior to this progress being made in these discussions with the tribe. So I don't know if Heidi would like to weigh in now and kind of discuss what they've been doing with Ms. Russo in more detail, if she'd like to provide that perspective.
Go ahead, Ms. Nesberg.
Hi. So I myself, I'm considered the monitoring worker of the case. So when Ms. Russo did move up here, I spoke to the tribe's foster care supervisor in our area. She is helping Madison meet with Mom and get her involved in services and meet any barriers that she does have. Mom has not been available at times for drug screens. Those were unannounced visits that Roxanne, our supervisor, was completing. I know there's been times where Mom has not been able to be getting a hold of, but she does know how to contact us, as she did yesterday. Mom, it's my understanding that she's going to counseling and doing some substance abuse services. As of yesterday, Veronica left a message for me that she was filing a report on Mr. Lovett for domestic violence with the state police here. We set her up with our domestic violence program, and they got her into a place so she could feel safe. Also, it is also my concern that when Mr. Lovett does make an appearance up here, Mom goes quiet, and it's disrupting any services progresses that she's made, unfortunately. So that is basically where we're at right now. I can say I've known Veronica for a long time. I've been around her other case. This is some progress on her part, but she needs to make consistent progress fast if she plans to get her children back, or her child back, I'm sorry.
Thank you. So let me hear from Mr. Hotchkiss.
Thank you. I have had an opportunity to review the report. I've reviewed the progress and lack thereof by Ms. Russo. I have spoke with her. Unfortunately, at the time I spoke with her, she wasn't in a position to where she could comment much or speak freely, it seemed. She did indicate to me that she was aware that that these services had been ordered, that she was participating, certainly to the best of her ability, and was committed to trying to complete the service plan. I do know that she struggles as a victim of domestic violence, and a lot of times that's a hard cycle to break. But she did tell me that she would like an opportunity to complete those services which have been ordered. Said she was working with the representative of the tribe, which we just heard from, and she does not want a goal change and wants an opportunity to complete the reunification process. Thank you.
And Ms. McCluskey.
Thank you, Your Honor. I have not had contact with my client, Mr. Lovett. So I don't have a comment on the recommendations or the request for goal change. I know obviously the court may remember Axel was placed with the father of his half sibling at the beginning of this case, and we requested a placement hearing and got Axel moved to the current grandparents, which are my client's parents. So I know he's comfortable with where the child is at. But otherwise, I have no further comment. Thank you.
If I may have one final word, Judge.
Go ahead, Mr. Brown.
Judge, I sat patiently and listened to Ms. Banks. I appreciate what she said, but I don't have any concerns for Axel's safety, and just putting a safety plan in place for the purpose of having a safety plan. The only domestic violence situation was not between the grandparents, and it did not occur in the house. It was outside. The Lovitts agree that Keegan should not be able to come over and have parenting time at the grandparents. They agreed to that, and that hasn't happened since it was put in place. But just to have a safety plan that they can't FaceTime with his son, I don't know, just to have it in place, there's no reason for that. And with regard to Ms. Rousseau, I've heard nothing here today that says she's made any progress. And from viewing the long-standing mental health issues of Ms. Rousseau, I don't think there's a service out there would get her to the point ever to place Axel with her. So I don't know why we're wasting time. We filed changes of goals on far less progress in other cases, and in fact terminated on far less allegations and lack of progress than this case. So I don't see why we're waiting around. Axel needs permanency. We would like to have a goal change. Thank you.
All right. Well, Mr. Brown, I share all of your concerns. However, we have the added component here of the involvement of the tribe. And the tribe currently is not supporting a goal change. The agency is not advocating a goal change. Go ahead, Ms. Nesberg, you can speak.
Just want to clarify on what typically happens with the tribe. When a goal change is requested by the agency, if they are requesting that, then I bring it to the Sioux Tribe's Child Welfare Committee and they make a recommendation. So if the agency were to change their mind, or if the GAL even wanted to request that and file a termination petition, then I bring it to the Child Welfare Committee and they make a recommendation on it. They haven't made anything formally at this time.
Ms. Banks?
And just to comment that as well, I would like to clarify, we're not against a goal change. We completely agree that this child needs permanency and that it has been a long time coming. I simply want to report what the investigations we have done as our hearing in, I believe, November dutied us with, was reporting what progress has been made, ensuring services have been provided to every extent, and things like that in discussion with the tribe, so that if we do have a goal change, it's airtight and we're not at a termination trial in which it gets overturned and we have to go back to reunification after the goal change. So we're not against going for it. There has been minimal progress and almost no progress for Mr. Lovett and minimal for Ms. Rousseau. So I would like to leave it in the court's discretion on how to proceed.
So, Ms. Nesberg, let me ask you, from the point in time when a goal change is presented to the tribal leaders, whoever the decision makers are, until a decision is made, how much time are we talking about?
So unfortunately, our Child Welfare Committee meeting for January is tomorrow. So if I got a termination petition from anyone this month, it would have to be by about, let's see, January 19th to be safe. then I would get it on the February meeting agenda, which is, I believe, February 6th, I believe.
So if I were to order a goal change today, the earliest it would be considered by the tribe would be the date you just gave me in February?
February 3rd, yep.
All right. Based on what I've heard and the amount of time that the child has been in care and the very little progress made by either parent, I believe a goal change is warranted, but I will certainly heavily weigh the position of the tribe as to whether or not that goal change should whether or not termination should occur. So I want to give the tribe an opportunity to evaluate and to weigh in as to whether or not it agrees that it's time for a goal change here. So I'm going to order a goal change today. I'm going to ask that a termination petition be filed 2 weeks from today at the latest. I'm not going to set a hearing for that. Just get your petition filed and in and get it to the tribe in plenty of time for them to be able to consider it at their February meeting. I'm not even going to set a termination trial until well after that date. And if the tribe weighs in strongly against termination, I will give appropriate consideration to their position. So let's do this. Shannon, let's what's our next date after February 6th?
February 9th.
February 9th. So I'm going to hold, well.
Judge, I won't be here that or the 16th.
All right, I'll set a review hearing for February 23rd. By that time, we will have the tribe's position. I will decide at that date whether or not to set a termination trial. With respect to FaceTime visits with either parent, if placement is willing to supervise a FaceTime visit between either parent and the child, but it has to be either. It cannot be both. There's no way in the world I want both parents participating on the same call. I'll leave that up to placement if they're willing to do it. I don't see any harm in that based on the concerns that were raised, and I don't mean to minimize those concerns, but those concerns aren't going to happen at a FaceTime visit at which only one or the other parent participates. So there'll never be a chance to materialize. Recognizing that if indeed I order termination of parental rights, the Lovitts are still going to have their son in their lives, and decisions they make as to the amount of contact they might allow in the future between their son and their grandson, it's going to be ultimately left up to them, although they certainly will now be in the position of being responsible for his safety and well-being, and they will be the ones responsible to protect him from his father. So we'll get that termination petition filed, and then we'll find out on the 23rd what the tribe's position is, and I'll decide on a termination trial at that time. The other recommendations will continue, services will continue. It'll be up to parents whether or not they participate. If I saw a dramatic turnaround in mother's participation, and I see she's left our hearing, that might impact my decision, but it would have to be a very dramatic turnaround. Axel's been in care far too long. Normally at this time, we would have ordered a gold change probably 3 to 6 months ago. So anything else the court needs to address today?
Just the time of the hearing.
Yeah.
I'm sorry.
The time of the hearing on February 23rd.
Oh, I'm sorry. 9 o'clock.
Thank you.
Thank you, Your
So
Honor.
I do have one question for Ms. Nesberg. Are you related to Ted Nesberg?
Yeah, he's my father-in-law.
Oh, okay. He was a classmate of mine at
I think
Manor
you
High.
had before, so I asked him and he said he remembered you.
Ah, great. Well, give him my regards. I couldn't tell you the last time I set eyes on him.
I'll let him know.
Probably when I was in high school. We won't say when that was. All right. Thank you, everyone.
Thank you.
Thank you.
Mr. Kelly, do you want to try to address our 1 o'clock this morning?
We can, but Tim's on that one. If we can get hold of Tim.
Yeah.
He's
Yeah,
got
maybe I can just send an email because Judge, we have our 1 o'clock trial. It's an in-person demand, and we can't do that yet. So I don't know if we need to appear at 1 o'clock or just set a new day. I could send an email and.
Well, that, and I think Tim requested a psych eval get done for Mom.
Yeah.
So we have a couple things going on, unfortunately.
I know. Why don't you shoot us an email, include Tim. If there's an in-person demand, obviously I cannot conduct a trial. So there's no point in having people show up at 1 o'clock. But let's connect with Tim with an email and so that we can address that.
All right, sounds good. Thank you. Bye,
I have-
everybody.
I have 2 cases that we haven't.
Hold on, I got some more stuff on my docket. Hold on.
The only thing I see is post terms.
We have the ball pretrial today. It was supposed to be set for
8:30.
8:30.
See, it's not on the docket. The worker told me about it, but
Not on my docket either.
Because we have a trial next week.
I don't know anything about it.
You scheduled it early, Judge. This was just up last week and you scheduled it early for a pretrial, then trial next week.
Shannon just got back today.
Yeah.
So she hasn't even seen that file yet.
Sure.
Well, let me take a look at it. It doesn't look like if
I mean, we have a trial next week. I don't know what there is to talk about too much.
There isn't.
Yeah.
But
if there's nothing to talk about, then I guess we can dispense with the pretrial.
The worker mentioned I didn't have it in my notes, so I told her to not worry about it until she heard from me.
If there are any issues, let's get an email chain going, and if it's going to be necessary to schedule a pretrial and push the trial out a little bit, I'll certainly consider that.
I don't think Dad wants it pushed out. He was adamant that it go quickly. So
yeah, that's why you said it so fast. But okay, do we have any? Is everything else post terms?
Let me see. Yes, I just have 2 post terms remaining.
All right, thank you.
Thank you.
All right, thank you. Have a good day. Okay, let's see. Let's do Marquis Walters. And let's see, Ms. Kirk is already here. Let's see who else is on that one. Do you have that report, Shannon?
Which one?
For Marquis.
Both these out.
Mattinson.
And no, oh yeah, right there.
Okay, and there's fires on this one. Okay, next matter is the matter of Marquis Walters. Ms. Kirk is here. Who's LGL on this one?
Ivan,
Okay, and Ms. And I'm sorry, do you pronounce your name Fire or Fear?
Here.
Fear, pardon me. Ms. Callie Fear is also present. Mr. Brown, how's Marquis doing?
he's thriving. He is the pre-adoptive home. They are both school teachers. One's retired. Marquis is absolutely thriving. I see that, and I have absolutely no concerns with this placement. They are wonderful. I see that anticipated date for adoption is January this month. I'm hoping we can achieve that. I know that mom filed an appeal. I don't have in my notes whether that appeal was denied or what the status of that was. But I think that's the only hindrance at this point in time. If the Court of Appeals has not issued a ruling, I am definitely in support of the Rogers adopting Marquis. He is thriving. Thank you.
I've got a copy of the Court of Appeals opinion affirming termination, but it's from last year. So is there still some kind of appeal of that's pending?
No, but I'm just not, I'm never, I don't get notice when an appeal comes back unless I.
Gotcha.
So, I mean, I guess last year was only 5 days ago, but I'm just glad that it's back. I think we can proceed.
So Ms. Kirk or Ms. Fear, are we looking at a January finalization?
I would say so. The only thing we were waiting on was the DHHS approval of the braces. Last thing I heard, that was approved. However, my supervisor reached out to make sure it was approved on December 29th. And she has not heard back yet, but as soon as we get word,
It's approved.
I'll have that out to you.
It's approved. I spoke with Ms. Hudson. I had a email from her that it's approved. He's already had his appointment with the orthodontist. So braces are ready to go on.
Okay, then I will get that mailed out tomorrow when I'm in office to to the clerk.
Very good. Ms. Kirk, anything to add?
No, Your Honor.
Very well. I will approve the recommendations. We will set one more review hearing if necessary for
March 30th at 9.
March 30th at 9 a.m. But hopefully we'll get this finalized in short order and won't need to have that hearing. Thank you.
Thank you. I'll see you next week, Judge.
Okay. And lastly, Dalen Wilson. Oh, that's not lastly. We have two more. Pardon me. Let's see. We'll let Ms. Urchin and Ms. Banks, I think. No, I don't see her. Ms. Urch, this is a matter of Dalen Wilson. Do you know who else is on this file?
I believe it's just me, Judge, since we have OTR OPC signed.
Oh, okay. And Mr. Kelly, you are LGAL.
Yes, Your Honor.
How is Dalen doing?
Your Honor, I called placement and did not receive a return phone call. I have reviewed the report. I have no objection to the recommendations. I'm in agreement with the ultimate goal of adoption.
And Ms. Urch, do you have any updates for the court?
I have no updates to my report. We're just waiting for that 56 wait day period to end for the competing party, and I believe that's going to be February 2nd.
Okay, well, I will implement the recommendations. We'll hold our next review hearing on
March 30th at 9.
March 30, 9 o'clock. Thank you.
Thank you.
Okay, last case up this morning is the Decker miners. I let everyone left in my waiting room in, so I don't know if you all are on this file or not.
No.
No, Your Honor, I'm not as well. I'm not either.
Okay, well, did we miss you earlier?
I was informed that there was going to be a preliminary hearing on 1-5 from Ms. Bates. It happened over the holiday. There was a 24-hour hearing from Judge Bates.
All right, so she scheduled one. We'll see if we can get a handle on that, okay?
Okay, thank you.
I do remember ordering a removal, so I'm assuming that's it.
Yeah.
Have you seen anything on that, Shannon? Let's try to track that down.
I mean, I've got one for one that's an in-home. But I'm not, I mean, that we obviously review. Only one I've got here is on Hudson petition. And it's an in-home, and I told him
That's the one. That's one where it's in home, but we removed from one parent. So there was a removal and there was a 24-hour hearing. So we need to finish the prelim this morning.
Matt said the kids are in home with dad. If so, judge usually handle those as inquiries and just schedules a pretrial. That's what Matt just told the agency.
Yeah, except when I remove from a parent. If we're just getting a parent out of the house, it's
I'm just
considered.
saying what he said.
Yeah.
So.
All right. I think we've got parents probably expecting something today, so we will deal with that. If you could track down at least whatever information we have on that. All right. So sit tight on that. In the meantime, we're going to do the post-term for the Decker miners.
Thank you.
All right. So who is on that file?
Your Honor, I'm guardian ad litem.
Danielle Lagore, I'm the foster care worker from Family Service and Children's Aid.
And Maria Kleckner, I'm the adoption caseworker with Family Service and Children's Aid.
Okay, Mr. Kelly, how are the Decker girls doing?
Your Honor, I run into the same issues as I always do. I don't get return calls. I haven't spoken to these girls in several months. And in talking with Shauna Watson, it sounds like she runs into the same issues as well in terms of sounds like cooperation. However, I have reviewed the report. I'm in agreement with APLA for Terry and the acronym of PPFWR for Trace. I think they're doing very good where they're at. We just wish we would have better communication. Thank you.
So what is PP placement in another Remind me what that stands for.
It stands for permanent placement with a fit and willing relative. It
Oh, thank you.
ultimately allows us to keep the case open to support the family until they age out.
And so at this point, the plan for both girls is no longer adoption.
That's correct.
And they're both doing well?
They are doing well. Yep. We just got Trace's orthodontist care approved. So she'll get braces. The family could not afford a class ring for Terry. So the agency just purchased that yesterday. And then lastly, the only other update I have to my court report is that I just completed new therapy referrals for the girls, and I'll get those submitted today.
Ms. Kleckner, anything to add?
I don't have to add to my report.
So what are we looking at for a time frame for continued court involvement in their lives?
So the goal change to the permanent placement with a fit and willing relative, it requires continued court involvement until they age out of foster care. Carrie, the eldest daughter, has indicated an interest in voluntary foster care, so her case might remain open as well for as long as she would comply with requirements.
All right. Well, what I know about these girls and remember about their family, it does sound to me like these are appropriate goals given their ages. And I will implement those goals, and we will set our next review hearing for
March 30th at 9.
March 30th at 9. Thank you.
Thank you.
So I'm going to see if we can find out what happened with that other case. Do we have a file? Do we have an order? Do we have anything at all?
Everything was sent. You were included on it on Wednesday, December 30th. Petition, order, continued allegations.
Can you print those out? That's probably what happened. I remember doing the removal. And Allison would have heard it on Friday. Well, that wouldn't have been Friday.
On
Sometime
Thursday.
last week.
Yep,
On
she's
Thursday.
seen it on Thursday.
Normally, they would have sent that her order with the file, wouldn't they? Do you know if that's on your desk somewhere?
I will check.
Peter stepped away, so. Oh yeah, I remember this. All right, while Shannon's printing stuff out, I'm gonna go walk in and see if the file isn't sitting on my counter.
Okay, thank you.
Okay, I have a file. Unfortunately, I don't have any lawyers here.
Yes.
Let me see if I can get them back.
Okay. Thank you. Judge, Lorraine Hudson, the mother in this case, says that she is in the waiting room, just waiting to be let in now as well.
All right, we'll let her in shortly. I'm right in the middle of sending an email to our lawyers.
Can I have the case number as well when you get a minute?
2038881. And let's see if anybody else. Do you know who would be next up if mom asked for an attorney, Shannon? Rebecca's LGAL on this one, I think. Yes.
Mike.
Mike Kelly, okay. See if we can get him back in. Probably don't have petitions. Okay, Matt, we have a continuation of a prelim that didn't make it to the docket. Hudson minors, children were removed from mom and placed with dad. So Mr. Hudson is present. Ms. Hudson is present. And I just sent out an email, as you know, Matt, to see if I can get our other attorneys to log back in so that we can complete this prelim today.
I saw that, Your Honor.
All right, okay, Mr. Kelly's here, and he would be next up. Shannon, would you, if you haven't already done it, would you forward Mike that petition that you just printed out for me? So Ms. Hudson, can you hear me?
Yes.
All right. There was a little confusion on this file, but we want to make sure it gets taken care of this morning. You are entitled to be represented by an attorney in this matter. Do you wish to have the court appoint someone to represent you?
Yes.
All right. Mr. Kelly, Shannon tells me you're next up. She's forwarding you the petition now. I can put you and Ms. Hudson into a private waiting room while we're waiting for the LGAL to show up so that you have a chance to discuss this matter with her. Ms. Hudson, I'm going to create a breakout room that allows you and Mr. Kelly, your court-appointed counsel, to visit privately without anyone else being involved. It will take him just a few minutes to get up to speed because he hasn't seen the petition yet, but we've just had that forwarded to him so he has a chance to read it, and then he can give you advice and we can decide how to proceed after he's had a chance to visit with you. Okay?
Okay.
Well, for some reason. Oh, okay, here we go. All right, just follow the on-screen instructions. Shannon, would you get a moment? Could you shoot a quick text to Rebecca? I sent her the email, but I'm not sure she's watching her email, if you don't mind. So Matthew, for your edification, when we do a pure in-home petition, we typically do not go through a preliminary hearing. We do a preliminary inquiry, schedule the matter for a pretrial. In this case, we actually did have to remove the children from the mother and place them with the father. So when that happens, we have to follow the normal preliminary hearing requirements in the court rule.
Sounds good, Your Honor.
Hello again, Ms. McCluskey.
Hello again.
We had one that didn't make it to the docket. Prelim, you were LGAL on the file. Hudson minors. Children were removed from mom and placed with dad. Mr. Kelly was appointed to represent mom, and the two of them are in a breakout room right now. We'll continue the prelim once they come out.
Judge, just tell her I just sent her.
Petition's on its way.
Thank you.
You're welcome. So, Peter, do we have all the briefs on that with this positive motion that's set for tomorrow?
I haven't pulled them together yet, but I'll get those to you.
They might be in the stack.
Yeah. Sweet.
Yeah. Thursday doesn't look bad at all.
I don't think Friday's bad either.
No, it looks pretty good. So, Mr. Way, what do you think of our basketball team so far?
They're looking good, Judge. They still got to play some tougher competition, but I don't know how you stop them. They can hurt you in just about every different way. Definitely a basketball school.
Yeah. I see Sparty finally managed to eke out a Big Ten win.
Hey now. I'm still on this Zoom meeting.
I know. I wish we could play them now instead of later in the season, but
yeah, they always get better.
They got Rutgers tonight. That'll be a good game, probably.
Well, when's our next game?
Michigan, I think, might play it tomorrow. Michigan State plays Rutgers tonight. Yeah, Michigan plays Minnesota tomorrow. They got another 7-footer, so that'll be an interesting one.
It's nice to see a big man in our lineup.
Yeah, Juwan knows how to use those big men.
Yeah.
A little different philosophy than the previous coach, although they look similar, but the personnel is going to look a lot different, I think, than under Beeline. I assume you weren't talking about the Pistons. You were talking about Michigan basketball, right?
Yeah, I don't pay much attention to the Pistons.
I didn't think so. I do, but I don't blame anyone else for not not doing so.
Well, and it's not just the Pistons. I don't care that much for professional basketball. I much prefer college ball.
Yeah, well, you're not alone in that. I'm a fan of both, but I get a lot of questions as to why I watch the NBA as much as I do.
Should I be filling out mom's form for her? Is that how we're doing that these days? Or do we
Yeah,
do?
I mean, I can do it. Doesn't matter.
Do you need her wage information though for that?
I usually, if they're not here, address and however, I mean, however you want to do it.
Just do it the way you normally do
Yeah,
that.
but just make sure I got an address and a right address, just let me know.
Yeah, I'm sure this is right here. I'll verify once I get on
Yeah.
the record. Well, I guess I can read some email while I'm waiting.
Do you want me to just take us off the record for right now, Judge?
You could, yeah.
Your Honor, I've had an opportunity to speak with Mom. If the court has time this morning, we'd be willing to essentially enter a plea to the effect that there's an issue with her sobriety and she would like assistance from the court to get that under control. I think that would be enough. And Mr. Wayne, would you agree? Would that be enough for the court to take jurisdiction and get involved in this case?
Absolutely.
Okay.
Okay. Yes, I can certainly take a plea this morning. Okay, Ms. Hudson, I'm going to ask you to raise your right hand, please.
Okay.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your full name for the record.
Lorene Ann Hudson.
Ms. Hudson, you are the mother of Ethan Hudson, born December 13th of 2005. Jaden Hudson, born June 10th of 2008, and Gavin Hudson, born June 21st of 2011.
Correct.
Were all three of these children found in the county of Jackson at the time the petition was filed?
Yes.
Have you read the petition, and do you understand all of the allegations that are made in it?
Yes.
If the court accepts your plea of admission today, there will not be a trial, and you would be giving up all the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses or testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you understand that you will be giving up all of these rights if I accept your plea today?
Yes.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your children temporary wards of the court, place them with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your children with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you understand these consequences?
Yes.
If your parental rights are later terminated, your obligation to support each child will continue until a court modifies or terminates the obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and such a challenge can include any issues leading to the disposition, including any errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions about anything I've told you so far?
No.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No.
Are you entering this plea of your own free will?
Yes.
Mr. Kelly, if you could please establish factual basis.
Ms. Hudson, would it be fair to say that the issues directly related to your sobriety are essentially responsible for, a good part of it is responsible for the allegations that are set forth in the petition?
Yes.
Would it be fair to say also that you would like assistance from the court to address your issues with sobriety?
Yes.
And are you willing to work in a case service plan to address those issues with sobriety in order to return to the previous custodial arrangement you had with your children?
Yes.
Does Mr. Way, do you have any further questions, or do you feel that's adequate?
I think that's sufficient.
No further questions, Your Honor. Thank you.
Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
I do accept the plea. I find that it was knowingly, understandingly, and voluntarily made. I find that the record supports that one or more of the statutory grounds alleged in the petition are true. Are we prepared to move forward with this position today, Ms. Blair?
Yes, I could. I can send Shannon a copy of it later. I didn't have one prepared up, but I can be.
What would be your recommendations?
Recommendations would be that she follow the recommendations from her counselor through her substance abuse counselor, which include meeting with her counselor regularly, random drops if necessary, and going to outpatient therapy appointments. If they've also recommended inpatient if necessary. And so we recommend that she follow through with those. We recommend a psychological evaluation just to see where she is with that and any mental health services that we can provide her with. She's already completed a substance abuse assessment, so that does not need to be completed. And supervised parenting time by DHS or its designee until she can start her outpatient therapy for substance use.
Those recommendations appear appropriate under the circumstances alleged in the petition. Mr. Kelly, do you have any objection?
Yes to the psychological evaluation. I think in reading the petition, Your Honor, that it's very obvious the sobriety is the main issue. I think that should be a priority to get that under control. Also, for the court's information, Ms. Hudson is the primary wage earner for the household. So we're going to need to have some assistance from the agency in terms of the services that are being afforded to her to work with her work schedule, because she cannot afford to not have employment or otherwise have that employment jeopardized, as the court's fully aware of our current times with the COVID issues and difficulty with our economy. Having an employment is a must at this point in time, especially for her household. So, because she is paying child support. So we would request that that be taken into consideration and for scheduling purposes or otherwise finding other service providers who will work with her. And finally, Your Honor, we would request discretion to go to unsupervised parenting time, because I know we're not going to be back here for probably another close to 90 days. I believe that next date is March 30th. I believe she has a good relationship with the father of the children. So we would request discretion for unsupervised or in the alternative as the designee has been suggested. Thank you.
All right. I do think that there could be some benefit of doing a psych eval. I realize we're not talking about mental health issues per se here in the allegation, but often underlying substance abuse, there are untreated issues. I don't see any harm in a psych eval. I think it could provide some additional insight to those to Ms. Hudson and to those treating her for her alcoholism. So I think that's an appropriate recommendation. I have no problem giving discretion for unsupervised visits, but I want to make absolutely sure that mom's alcoholism is under control, so that we don't have another potential issue arise. And I will certainly approve that visits be supervised by a designee if Mr. Hudson's willing to supervise.
Yep, I am.
That would be appropriate. I'm sure these children want to see their mother, and I'm sure she wants to see them. So anything we can do to maintain that bond, I think would be helpful.
Your Honor, considering what we're requesting of her to do, it sounds like there's a number of things labeled for her participation. Could we simply prioritize those? I understand the court's need and want for psych eval, but maybe could we put that a little bit down on the list so we can prioritize the services she does, so we're not overwhelming her with services. Again, she is the primary wage earner where we just cause any issues. Thank you, Your Honor.
Yeah, I think that would be appropriate. We don't need to throw everything at her at once. We don't want to overwhelm her. We don't want to undermine her employment. That obviously is essential going forward, that she be able to maintain employment. So I think that's a reasonable request.
Thank you, Your Honor.
So we'll schedule this for a review hearing on March 30 at
9:15.
9:15. Ms. Hudson, let me tell you, this is not a criminal proceeding. It's a civil proceeding. And the goal is to make sure your children are safe. And part of that goal means to provide you with whatever help and assistance we can in making sure that you are safe to parent them. And I wish you success in your service plan, ma'am. I hope you do well.
Thank you.
Okay, thank you, everyone. Sorry for the confusion about the docket, but I appreciate everyone's willingness to participate so that we could get this done today. Thank you very much.
Thank you, Judge.
Thank you.
Have a good day. Have a good day, everyone.